Thank you. Good morning, Your Honors. My name is Scott Dunham. Counsel, may it please the Court. My name is Scott Dunham. I represent the plaintiff and the appellant in this case, and that is Mr. Dean Doe. We are here specifically as a result of, in this instant litigation, a car accident that happened many years ago. A car accident that ended up having many separate claims, both with Mr. Doe's own insurance company and an at-fault driver's insurance company.
Counsel, I want to direct your attention to the statute, and I want you to tell me whether the language that provides health benefits or income disability coverage applies to all of the types of insurance coverage that are described there, or just some of them, and does the policy of insurance at issue here fit within that statutory definition?
Our position here, Your Honor, is that the collateral source statute and the point that you 548.36 subdivision 2 does not apply in this situation. This is not the collateral source that was taken in this specific case was taking a tortfeasor's liability settlement as a collateral source offset from a no-fault verdict. And given the nature of a tortfeasor's liability settlement, that does not, we would suggest to the Court, fit within the language of 548.36. It is not, because it is not health, accident, sickness, then it goes on to say, or automobile accident insurance that provides health benefits or income disability coverage. It's our position that it does not provide health benefit or income disability coverage.
And that clause applies to all of the prior insurance coverages?
In this case, yes. Yes.
Does that mean that an automobile accident insurance policy is outside the scope of that subpart?
I don't think it necessarily is always going to be automatically outside of the subpart. Mr. Doe's own automobile insurance company does provide income disability coverage and health benefits. And there are some circumstances where payments made by his own insurance company could fit within the collateral source offset, but that's handled in another way under the no-fault system.
I guess I'm having trouble following your analysis, because it sure seems that this tortfeasor policy is an automobile accident insurance policy. So why would that not mean that that fits within that subpart 2? I'd like to have you just look at that language and tell me how you take it out.
The way I would take it out is by focusing on the clause that the insurance provides health benefits or income disability coverage. The tortfeasor's insurance is separate from, in this case, Dean Doe's own insurance company, which is American Family. The tortfeasor's insurance company was a different insurance company that ended up reaching a settlement with Mr. Doe, providing compensation to Mr. Doe, but not specifically income disability coverage or health benefits.
But by definition, doesn't an automobile accident insurance policy not provide health benefits?
It doesn't provide health benefits to the person in issue in this case. The tortfeasor's liability settlement did not in any way, and under the statute, Mr. Doe could not have applied for health benefits or income disability through the tortfeasor's insurance company. It may have provided income disability or health benefits to somebody else with how the Minnesota no-fault system is set up, but would not provide those types of coverages to Mr. Doe himself.
But the language of the statute doesn't have that proviso, and it seems to me that an automobile accident insurance policy provides basic economic benefits under the No-Fault Act, and I guess my question is how you square basic economic benefits with that subpart 2. I mean, it seems to me that the only plausible way to read it is that it applies to all automobile accident insurance policies regardless of their coverages.
Well, I think that touches on exactly how I would answer that, is that it focuses on health benefits or income disability coverage. And it's a matter of the different types of coverage under a Minnesota no-fault automobile insurance policy. This is a case where what is looked at as potentially being a collateral source offset is the tortfeasor's liability settlement coming from liability insurance coverage, not from the type of coverage provided by Minnesota no-fault insurance that would cover health benefits or income disability.
So let's just talk about a different scenario, and that is where, let's assume there had been no-fault benefits paid. Are no-fault benefits set off under the collateral source statute against a liability insurance verdict?
Yes, under the no-fault offset statute. How it would apply in a case like this is a little bit different, given that this was a litigation for no-fault benefits in addition to underinsured motorist coverage. Our position is that two things. Number one, there's no no-fault set-off for the no-fault recovery. There was some no-fault benefits paid, and they got a credit for that under the no-fault statute. But as far as how the tortfeasor's liability settlement gets classified is different with the underinsured motorist coverage. I'm not trying to say that the tortfeasor settlement should be disregarded. It's important, but it's important not as a collateral offset. It's specifically important just in the calculation of what's recoverable under an underinsured motorist claim.
Well, if you had obtained a verdict for underinsured motorist coverage that was in excess of what the tortfeasor had settled for, there would have to be a subtraction. Is it called an offset?
Yes.
So there would be an offset under the No-Fault Act?
Yes.
Against the underinsured motorist verdict?
Yes.
You said there might be some situations where a tortfeasor's payments would be offset against a no-fault verdict? I thought you said that there may be some situations under your reading of the statute where the monies that a liability insurance company had paid in settlement would be offset.
What I might have been referring to is that I think there might be some situations where payments made under a no-fault policy for things like medical expense or disability income loss may be considered a collateral source offset in some other type of a tort, possibly. For example, if there's a non-motor vehicle-related accident, I think any no-fault benefits, a slip and fall, for example, while getting into a car, might have no-fault benefits payable, and the no-fault benefits might be treated as a collateral source.
Let me ask you just a couple questions about our rules of construction. Because I think what we're dealing with here is a statute that abrogates the common law in some way, and I want to just focus on the common law. Absent this statute, tell us how the common law would operate.
Yeah, I think the common law dictates how this claim should be analyzed. And throughout, when this case first came up, neither party argued that anything should be a collateral source. There was a no-fault claim and an uninsured motorist claim. And our position is using the common law, which is the Richards case. The Richards case dictates how this claim should be analyzed. The Richards case specifically talks about the distinction between no-fault coverages and underinsured motorist coverages and how they fit into the No-Fault Act. No-fault insurance coverage, which are the medical benefits and the income disability loss, are a first-party insurance system, whereas the underinsured motorist coverage is designed to supplement tort coverage. The reading of the Richards case specifically talks about the order in which a case like this, which combines a couple of different claims arising out of the same accident, can be looked at. Specifically in the Richards case, it's talked about making the no-fault determination first. And the only way you can get to the tort analysis is to figure out what are called actual damages. Actual damages are damages less what are paid or payable by no-fault benefits. In the Richards case, it was exactly the type of, and this would be the common law analysis, the Richards case specifically looked at what the verdict was, what part of the verdict was for no-fault benefits, what part of the verdict was for the tort claim. And in the Richards case, it was similar to the situation we had here. There were no-fault benefits recovered, but not an underinsured motorist recovery made because ultimately the actual damages were less than the tortfeasor's liability limits.
So my question was a little more fundamental, and that is, when we look at the common law and then we look at legislative action to abrogate the common law, how do we, is there a separate rule of construction about how we read the statute? And we have to understand what the common law is. The common law is that there are no deductions. Am I right about the common law is that the claimant enjoys windfalls? I mean, was that well established, that common law?
Yeah, I think so.
Because you have to concede here that there is a windfall to your client.
I would put it a little bit different. I would put different than a windfall. If the way we're suggesting that this would work is that Mr. Doe would in fact end up recovering more than what the jury awarded him in this jury trial, but it has nothing to do with any claims with American Family. The reason he ends up recovering more is because he accepted a $28,000 settlement in a case where, in hindsight,
maybe they overpaid.
Yes.
Okay.
Yes.
So they overpaid, and according to this jury, he's now enjoyed a windfall. I mean, I'm saying windfall because at common law, that's what we called it.
Yes.
So when the statute abrogates common law, which everybody concedes the statute attempted to do, I mean, do we read the words narrowly? I mean, is there anything that guides us in terms of how we look at this language and how we're to interpret it, specifically in this area where the legislature is carving something out of the common law?
Yeah, I would look at it, I guess, in kind of two parts. Number one, with the Balderrama case, that talks about what is recovered on a no-fault, that essentially that the tortfeasor's liability settlement is separate from what a no-fault claim involves. And by keeping them separate, I don't know that any type of offset needs to be accounted for when making the first recovery. And by first recovery, I mean the recovery for no-fault benefits. The Balderrama case specifically says that by settlement with the tortfeasor, your settlement means giving up something that you've got a right, you've got some type of a right to get. And in Balderrama, they discussed how when you're settling with a tortfeasor, you're not giving up the right to pursue first-party economic loss benefits because you wouldn't have had the right to collect that from the tortfeasor to begin with. And so because those are separate, Balderrama guides us that these are different types of claims involving different damages. And then going to the collateral source calculation, if you want to apply that just to look at the net result that the plaintiff get, again, I would focus on just the language of subdivision 2 not applying because this does not involve health accident. Again, the offset that's been taken at the Court of Appeals and at the district court level is an offset of the tortfeasor's liability settlement, which is not health accident or sickness or automobile accident insurance that provides health benefits.
So doesn't it arguably include basic economic loss benefits?
Well, there's a line.
There's no way to determine it. It was a settlement that has no parameters in terms of it's so much for this, so much for that, right?
Yeah, it was a general settlement, and there are lines of cases involving, some Court of Appeals published and unpublished cases that talk about settlements where you can look at the settlement and make a determination as to whether basic economic loss benefits were included. And on those types of cases, you're correct.
Let me change a little bit in terms of how we interpret this statute. I guess I'm sort of struggling with this windfall issue, and I'm wondering if we are guided by the other parts of the No Fault Act, and in particular the mechanism under the No Fault Act to provide for recovery of no-fault benefits and a specific provision that they're payable within 30 days, and if they're not paid, there's a remedy to, I believe, go to arbitration, if I'm not mistaken, to pursue and collect those benefits. And appellant did not avail himself of those rights under the No Fault Act, right?
That's correct. And that will get into what the respondent will argue is that the plaintiff had their choice on how to bring this claim about. One way to look at that and to try to square it with the No-Fault Act is to take a look at what would happen if these two cases were brought separately. If the no-fault litigation were done first, we would have had a different jury verdict form, meaning the jury would not have been asked to answer questions about things like general damages and pain and suffering. It would simply be the medical expenses that would have been paid or payable. There would be no argument in a situation where if this were just a no-fault claim that there would be no offset. Going through some of the other alternate forms like arbitration or something other than litigation, there's not a suggestion pursuant to Balderrama that there should be any type of offset for a general damages settlement that may have been reached outside of the no-fault case.
Now, let me just stop you there to ask a question. Under the No-Fault Act, is the claimant entitled to recover interest of 15%?
Yes.
Starting with the 30 days. Is there any provision for recovery of attorney fees?
Not at the time of this case.
Counsel, let me go back to the question that Justice Meyer and approach it from a different angle, is that we start with the common law. We have a statute that abrogates the common law. Now, you have an interpretation of this statute that says that is one type of collateral source, automobile insurance, which provides health benefits and income, could be read as four distinct types of collateral sources, one of which was automobile insurance. We have said in Dean that what the legislature meant to include as a collateral source is, we don't know. In fact, 10 years ago, there was an invitation to the legislature to clarify it. I think the question being asked is a fundamental question. When you have a statute that's not clear, and the statute abrogates the common law, do you read the statute in this broadest sense, or as a court are we to fall back to look what the common law does and do it narrowly? That, I think, is a broad question of how courts approach issues like that. What is your argument on that point?
Yeah, that's a good point, and I've read all the cases that talk about the issues with the collateral source statute, and understand there's ways to read it differently. But I think under any of the theories or ways to look at the collateral source statute, we fall back on this particular case that with a no-fault recovery under Balderrama, given that the damages that we're talking about are different. The tort settlement was not a settlement for medical expenses related and necessary caused by a motor vehicle accident. Because it's separate, the collateral source statute should not come into play. And as far as the other portion of this claim, the underinsured motorist litigation, I'll also go back to the Dean case. The Dean case specifically said that settlements with a tortfeasor's liability insurance company should not be a collateral source offset.
Counsel, let me just press you on one point, and that is, you elected to bring a lawsuit with both no-fault and underinsured in the lawsuit. Let's separate those. Let's say that the lawsuit was just no-fault benefits, and you got the verdict you got in this case, and then you have this. Let's just, for the sake of argument, say that a liability insurance payment falls within the definition of a collateral source. And I know you're not conceding that, but I just want to work through this, because the question still is, then under the statute, is whether you've already received these damages. Okay, so you have a no-fault verdict of medical bills and wage loss, and then you have a previous settlement with a tortfeasor. You still have to hold those two up and say, in this verdict, have you already been paid for some of these items by a previous payment? And it seems to me the difficulty is that you can't tell what that tort settlement was. You can't say how much of that was for health, how much of that was compensation for what you're now having a verdict for. And I'm assuming that's right. But the problem here is that you've got an underinsured. Let's just say you bring a separate underinsured motorist claim. Okay. And the verdict is what it is here, but $1,000. I'm not sure how much it was, but pull that up and say, have we received benefits to cover for these same losses? We have, and we've completely offset it because it's the same kind of damages, and you collect nothing. Is that how it would work if you had these in two separate lawsuits?
Yeah, I think if they went in two separate lawsuits, that's exactly right. What would happen if this were a no-fault litigation first is that... Oh, right.
See to litigate the no-fault. How would the collateral source statute then operate? Don't you have to say... when the damages include an award to compensate the plaintiff for losses by collateral source.
I think that fits into the cases that do distinguish themselves from Balderrama. When a settlement, and the example, there's a LeBeau versus John Deere case, which specifically is a case involving future, it was a scarring case that involved a specific claim for future plastic surgery done to correct the scar. And that was worked into a settlement very clearly, it was a court-approved settlement that was... You could tell that was included as part of the damages. Then that would be offset. In a case like this where it's simply...
Offset as a collateral source?
No,
that's what confused me, because I thought your argument was these are never collateral sources. They might be offset because of some other statutory provision, or they might be subtracted, but they're not collateral sources.
Correct. Yes, my argument would be that in a no-fault litigation like the one suggested, if it were clear that the underlying liability tort settlement included elements that were the same as what was being litigated in the no-fault litigation, then it would actually become a collateral source and become offset from the verdict.
Well, but how can it be a collateral source in one case and not a collateral source in the other? I mean, the statute says what it says. Either it applies or it doesn't.
Yeah, there's also a and I apologize if I'm a little sloppy in mentioning it, there's a no-fault offset statute separate from the collateral source offset, which would apply to motor vehicle litigation and what is handled with no-fault benefits.
Okay, so the collateral source statute isn't what requires the subtraction.
It does require subtraction. They both do.
I don't, it's 65 something, is that the statute you're referring to, the offset statute?
Yes.
Okay, so it's, and 65B or something, I don't have it quite, but that's what you're referring to here?
$65B.51, the deduction of collateral benefits.
Okay. Yeah, 65B.51 offset.
Yes. And just to finish my thought about if the no-fault litigation was conducted first.
But now is it what happens, and it's very important, I think, under 65B.51, that offset never would inure to the benefit of American family, but what it does is it reduces the victim's recovery. Is that correct?
Yes.
Okay.
Yes. And to go back to the example of if the no-fault litigation were done first, presented with a special verdict form tailored just for no-fault litigation, the recovery in this case would have been $29,000 as opposed to $20,000 or $21,000. The second lawsuit would have resulted in a zero for underinsured motorist claim. My position here is that while it's true that we may have some decisions to make and can have some control over how these claims are brought, we can have control over things like forum and maybe procedural rules and maybe expense and time of litigation. The substantive law shouldn't be different if the claims are brought separate as opposed to having them brought together.
Let me ask you a question about, instead of settling a liability claim, what if you'd gone to a verdict on the liability claim? And on the verdict form, we could see that your client was compensated for some medical bills and for some wage loss and for some pain and suffering. Then you have this lawsuit, which is for no-fault benefits, and your client is awarded medical bills and wage loss. Don't we subtract the amounts that you recovered in the first case for the medical bills from the medical bill award you now have? Or do we still not subtract them, even though we now know how much of that lump sum we can allocate to wage loss and disability, Do we still not subtract it because the policy that you collected it from, it's not a liability policy that provided health benefits or income disability coverage? I think this is what the crux of the argument.
Yeah, I think the medical bills do get subtracted in that scenario. I don't think you can claim that it's not. I don't think the argument is that
counsel just subtracted from what?
I think the medical bills awarded in the first hypothetical lawsuit would be subtracted from the award in the second hypothetical lawsuit. And I don't know if that's because of 65B.51 or the collateral source offset, but I think one way or another
that's
you
the
get
problem,
some
though,
result.
with your argument, which is, the argument under collateral source is that this is first-party coverages. If you've collected first-party coverages, health, disability, policy coverages, those are subtracted, but anything else wouldn't be subtracted. There may be some other rule of law that would offset, but it wouldn't be the collateral source statute.
Counsel, just so you're aware, you're into your rebuttal time.
Okay, thank you. I'll just end by trying to give an answer in that I think it would be governed by 65B.51, which is not a collateral source offset, but still a way to account for not getting double recovery. And I'll save the rest for rebuttal.
You have 9 minutes remaining for rebuttal.
Thank you.
Mr. Pryor.
Good morning. I'm Mark Pryor, representing American Family Mutual Insurance Company. What we know in this case is that Mr. Doe has damages of $49,416.13. That's been conclusively established by a jury. And that's the gold standard in our system for determining damages. There's no question in my mind that the tortfeasor settlement should be included in the offset. Once you get, in our system, you get a verdict. Then you look at what should be deducted from the verdict based upon other collateral source payments as defined.
Counsel, what payment was made in the tortfeasor settlement for medical bills?
You don't know that because it is a general release, which is a lump sum.
So how do we know what amount to subtract from the medical bills line on the verdict form?
You deduct the entire amount. It's because that's the statute defines accident insurance policy. So we've been talking about this morning is what is an accident insurance policy? An accident insurance policy is the common acceptance is an auto policy, which includes several coverages. It includes no fault. It includes liability coverage.
But when you make a motion to determine the collateral source payment, though, what's your evidence that you present to the court? What do you say, the plaintiff settled for $28,000. All of this was for medical bills? I mean, what's your proof on what the plaintiff has received?
In the case like this, you don't need to break out what was paid for medical because you don't know that. And quite frankly, the reason you don't know that is because when plaintiffs settle tortfeasor claims like this, there's a benefit to accepting a lump sum without defining what it represents. And that's what we have.
Well, the problem is that the plaintiffs settled. Maybe they made a good settlement. I mean, maybe they
did. And then, quite frankly, the verdict shows that they made a good settlement with.
No, but the verdict doesn't say what those two parties thought the claim was worth. I mean, the verdict doesn't.
They thought it was worth $28,000.
You still have to be able to show how much they've been paid for medical bills to offset it under the statute.
I don't believe that's true. The statute calls for an offset of payments made. It doesn't call for specific line items of a payment to be offset.
Well, the definition of collateral source would say that it's a dollar amount for health benefits paid.
I disagree. The collateral source statute says payments made by an automobile insurance policy, which includes, as I indicated earlier, several types of coverage. Now, later in the subsection, it talks about
What subsection, sir?
The portion we're talking about, the subsection that refers to medical and wage loss benefits.
You're saying that you can invade general damages.
Pardon?
You can invade general damages under the collateral source calculation?
Collateral source includes general damages. Whatever payments made under that policy is included under the collateral source statute.
Pain and suffering?
Yes.
Where does it say that it includes pain and suffering?
It's a payment made under an accident insurance policy. An accident insurance policy includes several types of coverages.
Now, you would agree that not only abrogates the common law, that more narrowly confines reimbursement. In other words, under the common law, you couldn't invade general damages.
If it was, well, I shouldn't say. I think the common law offset provisions, the common law talked about there shouldn't be a benefit for payments made that weren't related to the tortfeasor. That's the common law collateral source, is payments made that weren't related to the tortfeasor shouldn't be deducted, so a defendant doesn't get the benefit of a separate source that was brought in from the outside, basically.
But this isn't talking about benefiting the defendant in the tortfeasor. This isn't about benefiting the tortfeasor. This is about benefiting an insurance company that refused to pay for medical bills.
This is about compensating a plaintiff at the level of his damages, and that's what all of the cases that we've talked about today are. The goal behind all of them is to ensure that an injured plaintiff is compensated to the level of their damages without obtaining a windfall or...
Well, here's the problem I have with the argument in this case factually, because it's a $30,000 policy limit the tortfeasor has. And the payment was a discount off the policy limit.
That's correct.
And some amount of that is for pain and suffering.
Okay.
Some amount is for medical bills. Some amount is for wage loss. And I just want to clarify, your argument is that whatever amount was paid for pain and suffering gets to be offset against a later no-fault verdict.
Because when you get to a verdict...
Am I right that that's your position, that
yes,
pain and suffering awards...
because when you get to a verdict, and one of the things we need to point to, and one of the things in the Justice Association brief that's really critical...
I'm just going to set up... So you've got a no-fault award by verdict.
Right.
It does not include pain and suffering. You have a previous settlement that does include pain and suffering, and it's your view that the collateral source statute operates... Whatever pain and suffering award you previously got reduces American Family's obligation for medical and wage loss.
A general release settlement made is under an accident insurance policy, which the tortfeasor's policy in this case is an accident insurance, an auto insurance policy, is deducted as a collateral source under the plain language of the statute. And that doesn't, we know where we're going to get, because the purpose of the underinsured motorist coverage is to bridge that gap.
I'm not talking about underinsured motorist coverage. I'm setting up a scenario because I really want to understand how broadly you're reading the statute. We have a no-fault verdict. Let's take UIM out of it for a minute.
Okay.
A no-fault verdict awarding medical and wage loss benefits.
Okay.
We have the previous settlement, general damages settlement, that may include pain and suffering, medical bills, and wage loss. And we don't know how much of that is in that pot.
Yes.
But you're saying that whatever amount is in there, including pain and suffering, is completely offset against that no-fault verdict.
Yes, absolutely. And the reason that doesn't result in a problem is because the purpose of underinsured motorist coverage is to bridge that gap between whatever was deducted and the coverage that's available.
I'm not talking about
to ensure
underinsured.
that the plaintiff is fully compensated. And that's exactly what we have here. That's exactly the calculation that American Family is advocating in order to get to full compensation for the injured party.
I go back to the drafting of the statute in 1986 when it passed. Tell me why my reading of this statute is incorrect. It talks about providing health benefits or income disability coverage, and it seems to me clearly pointed, clearly is the wrong word with this statute, but it seems to me pointed in the direction of deductions for health benefits or income disability coverage, not for general damages.
You have to understand that there are separate types of insurance coverages available that have separate purposes and separate breadths. And there are first-party direct payment policies such as workers' compensation and health insurance and no fault, which are intended to pay medical bills. There are broader insurance coverage policies which include not only medical expenses and wages, but also pain and suffering damages. The liability portion of an automobile insurance policy encompasses not only wage loss and medical, but also pain and suffering damages. Had Mr. Doe chosen to pursue his claim solely against Ms. Wagner, the tortfeasor, absent any no-fault claim, and proven up these damages, that tortfeasor's policy would have paid both all the elements of the claim, which included medical, wage loss, and pain and suffering. And then had he chosen to pursue the claim against his UIM carrier, absent a no-fault claim, he would have gotten that recovery as well.
Now, I get the distinction between first and third party coverages, but what I'm struggling with here is the clause that says that provides health benefits or income disability coverage. It seems to me the legislature has in mind a collateral source rule abrogating the common law, but it's a limited abrogation. Tell me why that's not right. Because what you're arguing for here, just a moment, what you're arguing for here, I think you'd have to concede, is a very broad interpretation of what gets deducted from collateral source.
It's broad in that it's the plain language of the statute, which is a broad definition. Automobile accident insurance policy is a broad definition, and that's what it is. And the breadth of coverages, which include, in this case, tortfeasor's coverage and underinsured motorist coverage, includes and encompasses both wage loss.
So what did the legislature mean when it said that provides health benefits or income disability coverage? What does that phrase mean?
In order to be considered a collateral source, that type of policy needs to be able to pay that type of damages if its coverage comes into play.
So a liability policy which provides no health benefits or income disability coverage, but does provide it under the no-fault portion, would then qualify.
Can be considered a collateral source, absolutely.
Counsel, as I read this provides health benefits and income disability coverage, at least with respect to income disability, that sounds like a very technical or precise term. And it sounds to me like it reads to me as though it means more than simply liability payment that might cover lost wages. It sounds like it's talking about something very specific, income disability.
Well, I guess I would interpret income disability as compensation for lost earnings or lost earning capacity. Maybe not necessarily a limited loss of earnings, but possibly a future, which is something that falls under the general automobile liability coverages.
Counsel, I just want to, I'm sorry, I'm having trouble following both sides' statutory argument here, and this is the question I want you to answer. We have the clause that provides health benefits or income disability coverage. That specific clause.
Yes.
What is your argument about what that clause modifies? Is your argument that clause only modifies liability insurance, or is your argument that that clause applies to everything that comes before it?
I think it doesn't. It's a narrow. It narrows what is a broader definition, which I think frankly doesn't apply in this case because the broader definition applies.
So the broader definition would be what?
Automobile accident insurance.
So your position is...
Which could cover. Now, there may be something out there that wouldn't pay those benefits. Quite frankly, I don't know what that product would be. But in this case, we're dealing with a policy that provides coverage for those types of losses if proven, if it applies. Possibly a life insurance policy wouldn't apply. It doesn't provide payment for medical expenses.
Counsel, when Mr. Doe pays a premium to your insurance company, what is he paying for? He's paying for no-fault benefits?
Underinsured uninsured motorist benefits and liability coverage.
Now, my understanding is that Mr. Doe conceived in his brief that he has no underinsured motorist benefits.
I would disagree with the calculation of what you'd characterize the payment. There's a payment made, and I would characterize it as underinsured motorist benefits. The Court of Appeals characterized it as no fault. I would characterize it as underinsured.
And so how do you get to the point that it's underinsured? Because that's contrary to what is that right out of the box, the Court of Appeals says there's no underinsured motors here. It's that appellants say that there's no underinsured. I mean, I understand why you want it to be underinsured because it's easier to get to the point you want to be, but I want to find out why you say that is so.
When you do the math and you go to the numbers, and if you take the deduction of what has actually been paid, no fault benefits paid, and the tortfeasor policy, the $20,000 which has been paid, and you deduct that amount from the verdict, you end up with a gap, which is the difference, which is what was paid, the $20,000 that was owed, that was ultimately paid, and I would characterize that as underinsured motorist benefits. You've got to remember, the reason we're here is because...
Doesn't your policy with Mr. Doe provide that you're to pay medical expenses? It's first-party insurance, right?
Absolutely.
And is it, boom, I mean, it seems to be, is it, that's where you go, that's where you look for.
Right. And those can be paid, those medical expenses can be paid either under the no-fault portion of the policy or under the underinsured motorist portion of the policy. Mr. Doe could have pursued this claim absent any no-fault claim, and had he proven damages that exceeded the tortfeasor's limit, whether it was pain disability or wage loss or medical, if it all exceeded the disability, the tortfeasor's policy limit, then the remainder is underinsured motorist benefits. You pay it either way, regardless of how you characterize it. And that's why these coverages are very broad. The plaintiff has a lot of options to pursue these claims. The reason we're here is because the option he took didn't get him the result he wanted at trial.
Maybe the reason we're here is you only paid $800 and some for his medical expenses, and so is that he went after the tortfeasor. I mean, how do you explain the fact that you put that burden on him at that point? I mean, we do have a policy under the No Fault Act to have prompt payment, no litigation from first-party insured. That's you.
Right.
And is that when you don't pay, doesn't that put you're insured between a rock and a hard place, and why should you benefit by the choice that your insured makes at that point?
We didn't benefit by the choice. We benefited by the ultimate damages that were paid. And there was no benefit. He was paid.
Counsel, you just told me you benefited by the choice because you said he had a choice. He went after the tortfeasor first, and because he went after the tortfeasor first, you pay $20-some thousand instead of $29,000. Now, that seems to be that you benefit based upon the direction you took. Now, if I'm wrong, explain to me why.
I wouldn't characterize paying the damages defined by a jury, the full amount, every penny of the damages defined by the jury as being a benefit. You're right, under the system, that had Mr. Doe pursued his no-fault claim, had he pursued that first and recovered, he could have recovered under our system more than the jury awarded, the windfall that we've been talking about. I don't view paying every penny of damages that were awarded by a jury as benefit. And as a litigator who tries a lot of cases, you make decisions in the course of litigation, and sometimes they work for you and sometimes they don't. In this case, they didn't, but they didn't work out as well as they could have. But the fact is, we reached the result that we should reach here, which is paying the damages established by the verdict. And that's all the case law. The Dean case, all the other cases we've been talking about, they all view that as the goal, as to getting to paying the full damages and avoiding the windfall. And that's what we did in this case.
Counsel, if Mr. Doe had pursued American Family for his unpaid medical bills first, just for his medical bills, and he'd gotten the verdict he got in this case, American Family would not have an offset, and a check would have been written, and then Mr. Doe could have turned to the liability insurance company and negotiated a liability settlement.
Yes.
And American Family would not have enjoyed the benefit of that settlement. Is that right?
He could have, yes, he could have collected his no-fault in a separate proceeding. He could have pursued the $28,000, the settlement with the carrier, and he would have been able to do both those things.
Counsel, and this is, well, it does apply because we took a look at it in Nelson. And is that question being here is in Nelson we said that's the South Dakota case and the recovery, and we said that the insurance company would have benefited by what the insured received in the tort settlement, and that there were costs in achieving that benefit. For example, there would have been costs for Mr. Doe to achieve the $28,000 settlement against, we don't know what it was, but he didn't get the $28,000, I'm pretty assumed, because he had some costs of recovering that. But you would still deduct from your award any costs that he incurred in getting that $28,000. Is that right?
I guess I'm not sure I follow the question. The policy...
Legal fees. Well, expenses in getting the $28,000. He had to pay somebody to help him get it, right? And in Nelson, we said that, you should, under being a first-party insurer here, you should not benefit by your insured having to go against the tortfeasor to get a recovery.
Either way is whether the claim was pursued in the no-fault arena or in the liability arena as Mr. Doe chose to pursue it, he would have incurred costs. In fact, had he chosen, I would say that to pursue that in the no-fault arena, it would have been less because, quite frankly, the no-fault system is designed for quick, speedy, efficient resolution. It incurs much, much less in the way of resources in both court time and lawyer's time to resolve cases that way than it does in the jury system, which Mr. Doe
does that work when he has $29,000 of medical expenses and you pay $800? That necessarily doesn't play out that way.
Well, it certainly could. With no fault, there's a question of sequencing. You've got a limit for liability as to bring a claim. You've got a $10,000 jurisdictional limit, but you can bring it any number of times. And a no-fault proceeding, quite frankly, takes about an hour.
So let me back up for a second. I'm still bothered by the statutory construction, and I just want to make sure that I understand your argument. It seems to me under Subdivision 1, when we look at the first clause, which defines collateral sources to mean payments related to injury or disability in question made to the plaintiff or on behalf of the plaintiff, by or pursuant to, and then it goes to Subpart 2, and I'm going to skip automobile accident insurance or liability insurance that provides health benefits or income disability coverage. I take it that your argument is that the Subpart 2 simply describes the insurance policy and the operative language is in the first clause, injury or disability in question, and you're reading that phrase to include injury and disability broadly to include pain and suffering, basic economic benefits, etc.
All of those things are covered under an accident insurance policy, be it a liability policy portion of the policy or an underinsured, uninsured motorist portion of the policy. All of those damages are covered under the purview of those policies.
Counsel, if everything is covered, why wouldn't the legislature have just said automobile accident insurance or liability insurance and left it at that?
I don't know. I think that there may, like I said, there may be an insurance product that would not include wage loss. It may not include loss of medical expenses, and maybe that's what's being distinguished there.
Does your don't know answer create ambiguity with respect to the interpretation of the statute?
Absolutely not, because it covers the insurance that we have here, which is the broad coverage that envelopes all of those things that are laid out in the statute. I think it's plain language to me. And I think the last point I guess I'd like to address is I think that this type of result, which is payment of the full amount of the damages, and the confusion that results actually encourages and settlements and partial settlements. I really disagree heartily with the amicus brief that was submitted, that this kind of complication actually encourages partial settlements, which could have been reached or we may not have had this issue. But the bottom line issue is the jury verdict, which defined the damages, was paid in full under the collateral source steps that are advocated by American Family.
Thank you. Mr. Dunham, you have 9 minutes remaining.
Counsel, I don't want you to go outside the record, but is there anything in the record would indicate why Mr. Doe proceeded against the tortfeasor first as opposed to the no-fault benefits of American Family?
No, there's nothing I can add without going outside of the record. What I'd like to comment on is that in the Minnesota no-fault system, as you're hearing, there are multiple different types of coverages, oftentimes involving the same insurance company arising from the same motor vehicle accident. There are going to be some situations where there are some multiple claims brought in the same litigation. And Minnesota law is already very clear on establishing a protocol on how to sort through all this, and that's in the Richards case. What American Family keeps insisting on is skipping the step of calculating the no-fault recovery before getting to the underinsured motorist coverage.
Counsel, you keep going back to Richards, and you got to clarify for me is that your position on underinsured motorist coverage in this case. Court of Appeals says that there is no underinsured motorist coverage. I believe that you conceded in your brief that there is no underinsured motorist. Respondents say, well, you do the math and there is. What is your position on that issue?
Yeah, my position is that there is not a successful recovery for any benefits or money under the underinsured motorist coverage. I get there a different way than the Court of Appeals got there. The Court of Appeals first calculated whether or not there was going to be a successful underinsured motorist claim. I think you can't do that calculation until you figure out what the no-fault recovery is first. And again, I'll go back to Richards. Richards explains the differences between the two different coverages and how in a no-fault system that is designed to have first-party benefits paid as you go, and an underinsured motorist coverage, a policy that contains uninsured motorist coverage, that coverage is a tort-based coverage, and that comes after the first-party benefits take place.
So do you say that looking for underinsured, it comes after the $29,000, and because the award is $49,000 and the limits are $30,000, there is no underinsured? I mean, I want to figure out the math as to how you get there specifically.
Yeah, how I got there is first calculating the no-fault recovery, which would be the $29,000. Adding that to the $800 and some dollars that were paid brings you up to $30,000 that were paid. Actual damages is defined in Richards as damages outside of what's been payable by no-fault insurance. Actual damages in Dean Doe's situation would be the medical expenses above and beyond $30,000 and the $10,000 that were awarded for pain and suffering, which falls under the tortfeasor's liability limits. So I agree, just get there by a different route than the Court of Appeals did as far as the underinsured recovery. But I think in a situation like, or in a forum like Minnesota No Fault, there has to be a set of rules as far as how to make sense of a verdict form and allow parties to be able to bring multiple claims for the sake of judicial economy, for the sake of consistent verdicts, for the sake of anything. What strikes me with Richards, the comparison with Richards, is the insurance company in Richards argued exactly the opposite of what is being argued here by American Family. In Richards, the difference was that the tortfeasor settled with a $10,000 gap between what a settlement was and the tortfeasor's liability limits. What I'm getting, probably taking too long of a route to get to say, is that by doing it the way that Richards dictates isn't always good for the the plaintiff isn't always good for the insurance company. The facts of the case will determine what the ultimate recovery is, but there already is set in place a system for making sense out of a verdict form. And going back to whether or not Dean Doe in this situation ends up getting more money than what was awarded by the jury in 2007, I simply go back to the fact that he made a good deal with the tortfeasor's liability insurance carrier, and that American Family in this situation or in any other future no-fault litigation involving similar or comparable issues should go back in and take away whatever the benefit of the bargain was made by the injured party.
Clearly, counsel, the legislature would have the authority to say, to arrive at the result that counsel for American Family argues that they did. Obviously, it must be your position that the statute doesn't get them there.
That's correct.
And so I would go to the question that Justice Paul Anderson suggested, which is, does the qualifying language that I've been asking about, dealing with medical or disability coverage, does that apply to just liability insurance, or does it apply to all of the types of coverage that are described in that subdivision?
And you're talking about the collateral source offset subdivision too? I think it's I think it's designed to be any type of insurance that's providing health benefits or income disability coverage.
So it would apply to automobile accident insurance. In other words, you can take each of those clauses out and apply that descriptive clause to each type of coverage.
Yes. Yes. And if this were liability...
So just to be clear, so that you would read the statute as saying, and we're looking at subdivision 1, paragraph 2, health insurance that provides health benefits.
Yes.
Doesn't that seem a little silly?
I think if health insurance paid for medical bills that were subsequently awarded in a tort claim against somebody else, against a tortfeasor, that would be a collateral source and fit within the language of the statute. Unless there's a provision to pay back the health insurance company, and I think that's covered later on in the subrogation statute.
Well, don't we have to read insurance to modify health, accident, and sickness? Otherwise, it just says health, accident, and sickness.
Yes,
it doesn't say insurance after health, accident, and sickness.
I would read it, the only way that makes sense would be health insurance, accident insurance, sickness insurance. Yes.
Okay.
And with that, unless there's any more questions, that's all I have.
Thank you.
Thank you.
This matter will be taken under advisement, and an opinion will be forthcoming.